Is it? Hey, it's way back when you said that she gives you owl vibes. I mean, that's just as bad. She literally just came in and was like, give me owl vibes. I'm like, I'd be offended. I'd cry. Yeah. But she didn't follow with that. Karma.
I got to see all, you know what I'm saying? I hear you.
I don't buy that as a compliment. I said I would have cried.
One week in December, he's like the rest of the year.
I got my people geared up.
Weston should be a little bit older.
Nice. I'm gonna get 6 not guilties, set for 112, and then KBS on 1. Like that. Gone.
Mr. Gomez gone for the day?
I don't know.
Oh, plea agreement. That's, I know that's JC.
Okay.
Let me see here, let me see here.
Same with this guy.
That's my
You doing
stuff.
okay? Pretty good. Can't hear a thing you're saying. Yeah.
Oh, okay.
But you didn't say you apologize or elaborate. You just said you give me owl vibes.
Oh, my wrist. My wrist.
Yeah.
I got a plea for my minimum signature.
Yep, he gave me that stack of stuff that y'all have talked about.
Yeah, no one else, I'm not gonna pay anyone else in the Red Rock, just this guy. Garrett, the guy who was out here earlier and said he wanted the deal.
Okay. And that's all worked out, right?
Yeah, it's
Digging. Digging.
2-year probation, there's restitution of almost $4,000.
Okay.
No contact with the victim, no return.
Okay.
Summers. Nice job. Alright, rock this one. What is it? I didn't hear that yet. Rock and roll.
So he has a
my friend.
burglary conviction from 2016 when he got in prison.
Yeah, he went away, so you didn't have one of those. But when if you're scoring it, he knows the level of degree without going to CCIS and pulling up the
49 scores or something. No, I'm saying like something random.
grand theft. Sounds like he's gonna score if it's a, well, depends what kind of
It's
burglary
still
it is.
open. They closed it for the police.
But that should be sit.
It's only if it's in front of the court.
Look, they're even putting the counsel type. Private lawyer up here, and now it says conflict counsel.
Is it a DOP plea or
On a petty theft, that's well documented.
that's an interesting point.
Guilty, convicted of petty theft.
You say not before the court. Let's say hypothetically, Judge won't release this case.
So they're just doing, he didn't do probation, I guess, because everybody's looking at his record. Yeah, he's not.
In the same. It's transferred together, then it's all together.
Ready, I'm on. 1, 2, 3, 4. Out of custody. The rest, I'm sure, are just running a little late, you know?
I'm sure.
It's a long line at the security
When
center.
did he take this plea?
What is it? Is that drug court plea or? Oh, you're looking at something different.
Please silence cell phones.
Uh, 12/16.
All rise. Court is now in session. The Honorable William Stone presiding.
Good afternoon, please be seated. All right.
Chris, you got that? Yeah. Go for it.
Oh, it's cold. Feels cold.
Afternoon, Your Honor. I have Mr. Pham Minh Min, excuse me, I'm sure I'm butchering that name.
Okay.
He's present. It's 25 CF 2243. You got the informations? You have the informations? Your Honor, at this time, we'll acknowledge receipt of the information, enter a plea of not guilty, ask to leave, waive formal reading, ask to leave this set for the next court date.
Madam Clerk,
January 12th.
January 12th.
This may be a pretrial, Your Honor. If it is, paperwork's complete, we waive his appearance on January 12th.
Yes.
Thank you, Your Honor.
All right. Thank you now. Stay in
Thank you,
touch
sir.
with your lawyer.
That's it. Call my office next week. I don't think I have anyone else present in the courtroom, Your Honor, but, oh, no, I'm sorry. I do have Mr. Aiden Morrill, Morrill. Case number is 25 CF 2148. He's present and approaching.
Information has been filed.
Your Honor, we'll acknowledge receipt of the information, waive any formal reading, enter a plea of not guilty, and ask to leave this set for the next court date.
Is there an offer?
There is, Your Honor, and I've discussed that with my client. I haven't had a chance to look at any discovery yet, so I don't want to move forward. Or, excuse me, there is not an offer on his case, because there are victims that the state needs to speak to.
All right.
And also, I haven't looked at discovery.
All right. Next court date, Madam Clerk?
January 12th?
1/12. Stay in touch with your lawyer. You'll be back on the 12th.
Call my office next week. Your Honor, I do have Mr. Mr. Merritt for a plea.
All right.
But he's still in custody. I don't know if you want to do out of custody first.
Is that the only one we have left?
No, we have,
Say again?
Mr. Barrett and 4 more beside him.
Okay.
Your Honor, if I may approach real quick.
Granted. And Mr. Koch, who do you have in the gallery?
Judge, I have Mr. last name Pearson, first name Dexter.
All right.
He's present approaching
Do
25
you have
CF.
your informations?
Yeah, information has been filed, Your Honor.
Okay.
We'll be entering a not guilty on both counts. Current offer is 11.29 days, 11 months, 29 days, Okaloosa County Jail, Your Honor. We keep this set on the 112 docket for the not guilty.
All right.
Excellent. You're good to go. Just schedule that appointment. Judge, next is last name with a Q, Carrier. First name Carenza. Now it's with a Q, Carrier, 25 CF 2241. Judge,
I do not show that information's been filed.
information has been filed, 2 counts, Your Honor. Possession of controlled substance and paraphernalia. We'll be entering not guilty, both counts. Waive formal reading. Request this be kept on the 112 docket.
All right, is there an offer?
Not at this time, Your Honor.
Okay. 112 it is.
Thank you, Judge.
Thank you now.
Just make that appointment. You're free to go. Next is last name Sawyer, first name Sierra. Sierra, last name Sawyer, 25 CF 2242. She's present and approaching, Your Honor. Judge, information has been filed. We'll be entering not guilty on all 4 counts. Waive formal reading. There isn't a current offer. Request this be kept on the 112 docket.
I give you an offer.
Sure. Offer
Yeah, withhold 3 years of probation.
will withhold and 3 years of probation.
Yeah.
Okay. Thank you, Mr. Snell. We'll still ask to be kept on the 112, Your Honor.
All right, very good. Thank
Okay.
you now. See you then.
Free to go, just make that appointment. And then Mr. Springman with an S, first name Allen. Allen Springman, 25 CF 2213. Yes, Your Honor. Information has been filed. The current offer is 36 months of probation. We'll be entering a not guilty. Waive formal reading. Request this be kept on the 112 docket, Your Honor.
Is there an offer?
The 36 months of probation, standard probation.
All right. See you on the 12th. Stay in touch with your lawyer.
Here's a copy of his information.
Thank you. That's all I had out of custody, Your Honor. If I may approach with Mr. Snell for that stipulated bond motion from the pretrial detention hearing.
Granted. Now, who we got back there for the,
Sure. No, me? I needed merit.
well, I've got several others on the list today for both you and Mr. Cochran, Mr. Koch. I got Donnell McLean.
Yes, Your Honor, he's here. I was going to address him after Mr. Merrick.
Okay, okay. All right, and then Mr. Koch, I got several others for you as well, too.
You said he has several others
For me, we can address them now. They're
Well, I just,
Oh.
I didn't know if you were aware we had others on the list, considering the confusion we've had with the dockets before. You're aware you've got others?
yes, Judge.
Okay,
yes.
all right, good. Let's have Merrick.
Your Honor, I will need a signature from the state.
Okay.
You're only charged, you're only charged with, this is all they actually charge you with on the information. So these are charges. Mhm. All right. You sign and date here.
Dude, I'm talking about one of those people from like 3 weeks before this.
These are only 2 cases that I have for you.
Okay.
You're talking about the
It's 12/11/25. Oh, we do have a third case for you. Oh, yeah, I'll write that in. Okay. Just go ahead, or you already signed.
Your Honor, I'm sorry, there's one change I need to make to the plea form.
That's all right, sir.
He has a third case that wasn't, that I didn't add. I should add it.
I just need to add a charge that wasn't on there, Your Honor.
Okay. Hey, does the score sheet have all three cases on it? It should.
I'm sorry, Your Honor.
Yeah, it's on there. 18, 68, 67, okay.
Your Honor, there is a case, he has a third case that's not on the docket that we're pleading out also.
All right. Be sure Madam Clerk has that number.
Yes, Your Honor, it's 25 CF 1845. And I'm sorry.
Thank you.
Yes, Your Honor, my client's going to enter a plea today on three cases, 25 CF 2267, 25 CF 2268, and 25 CF 1845. As to the 2267 case, it'll be an adjudication of guilt, 3 years probation, cost of defense, cost prosecution. The 2268, count 1 and 2 would be an adjudication of guilt, 3 years probation, restitution in the amount of $3,973.40 to Mr. Leon Wilson, no contact with the victim, and no return to ICE storage at 921 Harrelson Drive, Fort Walton Beach, cost prosecution, cost of defense. And then 25 CF 1845, it's going to be an adjudication, 3 years probation, cost prosecution, and cost of defense. Your Honor, I would ask that the first 6 months of his cost of supervision be waived. He has been in jail for a couple months off and on, so he's not employed. I'd ask that first 6 months.
No objection.
If I may approach, Your Honor, I
Granted.
have signed an agreement and the police form.
Raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, Your Honor.
All right. You can put your hand down. You heard what Mr. Cochran said. You signed the written plea form.
Yes, sir. Yes, Your Honor.
How old are you?
Excuse me?
How old are you?
41.
How much school do you have?
Currently a student, but I'm not sure if I'm still a student now that I've been incarcerated for so long.
All right. So how far in school have you gone?
I've graduated high school, and I've spent about a year and a half of college.
All right. You able to read and understand the plea form?
Yes, Your Honor.
And did you do that before you signed it?
Yes, Your Honor.
And it's what you read in the plea form, what Mr. Cochran just announced to me.
Yes, sir.
All right. And you've got these cases that were announced and the charges that were announced, and we're taking care of them together today, right?
Yes, sir.
Do you understand this plea arrangement is having you plead no contest to these charges?
Yes, Your Honor.
And I understand a no contest plea to say that you believe the state could prove your guilt to a jury and you're not going to contest that.
Yes, Your Honor.
Do you understand by making this plea, you're waiving your right to a trial by jury where the state would have to produce that evidence and prove your guilt beyond a reasonable doubt?
Yes, Your Honor.
In this case, you'll be adjudicated guilty beyond 3 years of probation with the standard conditions, plus the no contact with the victim and no return to the place announced. and the restitution that was announced. Is that your understanding?
Yes, Your Honor.
And has Mr. Cochran answered all your questions about the plea and how it affects you?
Yes, sir.
You satisfied with how he's represented you?
Yes, sir.
The court will find the plea to be freely and voluntarily entered into and will accept the plea. Thank you.
Thank you, Your Honor. Thank you, Mr. Cook.
Judge, if I call the remaining of my docket.
Yes, sir, please do.
Last name Payton, first name Miguel Payton, 25 CF 2199, Miguel Payton. Fortunately, he is not present, Your Honor.
State,
Capias?
issue a capias, Madam Clerk.
Next case is double last name Saavedra Vasquez. Saavedra Vasquez, first name Melvin, 25 CF 2093, Your Honor.
All right. And this is the person that we believe may be in other custody, correct?
That is correct, Your Honor.
Okay. What's the state's desire?
Judge, given he also didn't appear on November 20th, we request a capias at this time.
Issue a capias, Madam Clerk.
Judge, next case, last name Sanders, first name Destiny, 25 CF 2193. Unfortunately, she's not present, Your Honor. She has made contact with my office, and I do have an appointment with her on 12/16. I'm asking if I can waive her appearance, keep this set for 1/12.
State?
No objection.
All right, we'll leave it set for 1/12.
And lastly, I have last name Schofner with an S, Schofner, first name Nicholas, 25 CF 2089.
All right.
Judge, I just checked, he is in custody at Citrus County. I wasn't able to look into the charges or get into the clerk's side on that case, but he is in custody.
All right. State?
However the court would like to handle that, I'm not,
Do you want to reset it to the next arraignment, see if you can get the information necessary to figure out what's going on?
I think that would be good. I'm good
All
with
right,
that.
reset for 12/18, please.
Thank you, Your Honor. And that's all I had on the docket.
All right.
Thank you.
Well, I show, did we take care of McLean?
McLean, yes, Your Honor, I set
Oh.
him for 112.
Okay.
Sound good, Your Honor?
Did we call you? Oh, no, McLean, I don't think I did pull him up, Your Honor. I'm
Okay.
sorry.
Little confusion. Come on down, Mr. McLean.
How you doing?
Sorry about that.
Long time.
Yes, sir.
It's,
Good afternoon.
good afternoon, sir.
We have information, Madam Clerk? Your Honor, we'll acknowledge receipt of the information, enter a plea of not guilty, waive formal reading, and ask for this to be set for the 112 court date.
All right.
That's your comment.
Is there an offer?
There is, Your Honor. I've discussed it with my client. We're going to set a meeting up and talk about the offer.
Okay. Stay in touch with him and be back on the 12th.
Thank you, God bless.
Thank you now. Good
Thank you,
day.
Your Honor. May I be excused?
Yes, sir. Good day. Mr. McKinney.
Judge, I have Erica Woods, present and approaching. She's here in 25 CF 2238 for arraignment.
Copy of information.
Will acknowledge the receipt of a 3-count information, waive its formal reading, and her plea of not guilty. Ask for this to remain on the next scheduled court date.
Madam Clerk,
January 12th.
112.
I don't believe there's an offer at this time. However, I've discussed with Ms. Woods that she needs to make an appointment ahead of the next scheduled appearance.
The offer today is 11 months, 29 days in the county jail, followed by 2 years of probation.
Never happening.
Hey, we're
Sorry.
not gonna say anything. We're just
Thank
gonna-
you.
Okay. All right, we'll see you on the 12th.
Thank you.
Stay in
Mr.
touch with
Stone.
your
I'll be
lawyer.
here. Thank you, and thank you. I'll be in touch.
I also have a William Turner
William
It's
Turner,
scheduled.
please.
on the arraignment docket in 25 CF 2262. Judge, I don't see him in the courtroom. I will say that he has another case that's already scheduled for the 12th for a pretrial. He was arrested at pretrial this last go-around and then released on an ROR bond. And this is from the same general set of events. So we had discussed,
You're talking about Mr. Turner?
yeah, we had
So,
discussed
yes.
consolidation of these cases, but he is not present here today. I don't know whether that's because he thinks it's the January 12th or he had notice for today.
He wasn't here last meeting.
He was here last night and he got arrested.
Okay, when the warrant was served, okay.
Correct.
Okay.
So I'll defer to the court as to issue a KPS or not.
Look.
I would ask for this.
State agree to leave it on 112.
That's, yes, sir. May we approach on this briefly?
Yes. And I think that's it for you, Mr. McKinney.
For the arraignment docket, yes, sir.
Okay.
Several more.
Padilla, Samir Padilla. Good afternoon. You're here today without an attorney. Do you want an attorney to help you? Do you understand English?
Yeah, I do.
Do you want a lawyer to help you?
No.
You don't want a lawyer? Okay, what's the state's offer?
It's a withhold of adjudication, 2 years of probation, substance abuse evaluation, any treatment that's recommended, and complete 24 hours of community service work.
Did you understand what he just said?
Yes,
Do you think you can do that without a lawyer, or do you want a lawyer to help you?
I can afford a lawyer.
Say again?
I can afford a lawyer.
You cannot afford a lawyer?
Yeah.
One can be appointed to represent you at the state's expense if you cannot afford a lawyer on your own. Is that what you'd like to do?
Yeah, I can't afford a lawyer.
Do you understand? I understand you can't afford a lawyer.
Yeah.
However, if you can't afford a lawyer, the court can appoint one to represent you at the state's expense. That's what the law provides. Would you like me to do that?
No.
You don't want a lawyer. Do you understand what I'm saying?
Yes, I do.
Okay. You do not want a lawyer to help you.
No.
Okay. I'm not sure I understand your responses. You're saying you can't afford a lawyer. You do not want a lawyer. You think you can go forward without a lawyer helping you? Do you feel comfortable accepting the state's offer? Is that what you want to do without a lawyer explaining it to you?
Like a public defender?
Yes, sir? You don't want someone to represent you, okay? Are you prepared to enter a plea today, then?
Judge Mann?
You may. All right, sir.
Judge, he's indicated to me that he wishes to have an attorney to represent him. I could bring us to a public defender application, or the court could provisionally appoint.
I'll provisionally appoint, and then you can assist him in completion of the application at a later time.
Yes, Judge. And providing Mr. Koch's information, he would be the attorney assigned, but I will acknowledge the receipt of a two-count information, waive its formal reading, enter a plea of not guilty, and ask for this to remain on the next scheduled court date.
All right, and did you hear the offer made by the state?
Did you hear that? Yes, Judge.
Okay, all right, very good, and we'll set this for 112, Madam Clerk?
Yes, Your Honor.
Okay, get in touch with Mr. Koch and be back on the 12th, okay?
Okay,
All right, thank you.
thank you.
Sulan Peña?
This is his name and information. You need to
Peña?
fill this out and turn it in at the clerk's office on page 1. If you don't want to fill it out, it's okay. Call him and bring it with you.
So they were added just day before yesterday to today? The case was put on yesterday. They were provided a notice to appear today.
This is a out-of-state fugitive.
Fugitive. What's the state's position on the fugitive, out-of-state fugitive? That's 25 CF 2357.
Okay, yes. The defendant was transferred back to the original jurisdiction, so at this time, the state would announce a no pros.
All right, case is no pros. Deja Terry. Looks like.
bond paperwork listed, today's date.
All right, thank you, Madam Clerk. State?
Did Madam Clerk indicate they had notice or
The
whatever?
bond paperwork had this date and time as their appearance.
Would request to KPS, Your Honor.
Issue a KPS. All right, who else do we have in the back now, bailiff?
Rico Williams, Mason, Weston, and there's one docket.
All right,
And we have John Smith and Grace.
all right. Mr. McKinney?
However you want to. Judge, Mr. Williams is approaching for the violations of probation. Case numbers 23 CF 1332, 23 CF 1913, 24 CF 115, and 24 CF 1493. We've been in active negotiation with the state. We've reached the framework of an agreement for reinstatement of supervision, but we need to have him evaluated to see if the 90-day program may be a good thing for him. So I've emailed Ms. Myers to be evaluated for the 90-day Bridgeway program, to kind of segue between his release and continued probation. So I'd like to come back next week. I believe that she should be able to get me an answer rather quickly, and we should be able to bring this back for change of plea on next week.
All right, 12:18 at 2 o'clock or 9?
9's fine.
12:18 at 9.
So I'll come see you probably Tuesday. She'll probably come out and see you earlier than that. I'm emailing her already. Do you have any questions for me? If we could just pause for a signature, Judge? Mr. Weston is before the court in a violation of probation. This is 24 CF 2818. What we have is a plea to the bench without agreement with the state. Originally, this was a withhold of adjudication, so the adjudication of guilt would be at the discretion of the court. We would waive a precedence investigation report. We have been provided a score sheet which reflects 32.3 points. There are minor corrections that I think that would be appropriate on the score sheet, because I don't think the misdemeanor should be applied, which is 4.4 tenths of a point. May I approach?
Granted. Is your intention to go directly to sentencing now?
Mr. Weston's intention is to go forward with sentencing now, and the defense is prepared to go forward with sentencing. I know in speaking with Mr. Snell that the state may not be in the same position.
Yes, the state would ask to put sentencing off. I have a victim in this case that would like to give input, and has been very involved or interested in how the case proceeds. And there's some witnesses. I didn't anticipate or know that this was going to take place today, so.
Right, and the nature of this plea would not be obviated by the requirement of your constitutional obligation, because this is without agreement. So this is an admission with no agreement, so a continuance of accepting the plea wouldn't be appropriate for your constitutional obligation. But sentencing would require you to reach out to the victims to provide them the opportunity to provide input according to your constitutional obligation. That's what you're saying?
Yes, sir.
Okay. So does that change your client's willingness to enter into the plea today? Because I think I would not be observing the requirements of law if I were to say we're going to go to sentencing without giving the state the opportunity to speak to the victims.
Judge, I believe in discussion with Mr. Weston, we would still seek to enter the admission to the court without agreement with the state for the court to sentence Mr. Weston, and we would just ask for the next available earliest date, because we are ready and prepared.
And I'll give you back the score sheet just so there's no confusion. Tendering to Madam Clerk, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you can put your hand down. Now, first, we'll just discuss, the state wants the opportunity to speak to the victim. That's their constitutional obligation. And Mr. McKinney has told me that you still wish to go forward with this plea, even knowing that you won't be sentenced today. Is that true? Is that your agreement?
Yes, sir.
All right. Now, according to this plea agreement, you're admitting the violation. Is that right?
Yes, Your Honor.
And by admitting the violation, what I understand you to say is that you agree that you violated your probation, just as the affidavit and a report says you did.
Yes, sir.
And do you understand, by making this admission, you're waiving your right to a hearing at which the state would have to prove that you violated your probation?
Yes, sir.
All right. And the agreement here, it is no agreement regarding the sentence in this case. Do you understand that?
Yes, sir.
And that means that the sentence would be completely at my discretion. Your score sheet doesn't mandate a prison sentence, but it does make you eligible for a prison sentence because you have more than 22 points. Do you understand?
Yes, sir.
All right. And you're facing a maximum potential sentence here of 10 years in state prison according to the charges against you.
Yes, sir.
Now, the purpose of this inquiry is to make you understand that by leaving the sentence up to me, it's completely up to me. I generally try to create some silly story to emphasize that it's absolutely up to me. So if I'm just having a bad day and somebody cuts me off in traffic and I spill my coffee in my lap on the way to court and I'm just mad, I could just put you in prison for 10 years. Now, it probably wouldn't be the right thing to do, but would be absolutely legal because it's completely up to me. Do you understand what I'm saying? Yes, sir. All right, it's completely in my discretion. So does that change your willingness to enter into this plea arrangement? No. We'll have a hearing where Mr. McKinney will have the opportunity to present whatever he believes is appropriate to support a proper sentence in the case, and I'll listen to that at that hearing. And Mr. Snell has indicated he'll also reach out and have input from the victims, which I'll also consider in reaching what is an appropriate sentence in the case. Mr. Snell, when do you think you can have that done and be prepared?
Your Honor, Mr. Weston absconded and left the state and had new charges in the state of Alabama that I need to get information about that I think might be pertinent for the court to know. So I would ask for, I believe did you have a 22nd day of January date? I think would be appropriate, or would allow me the time to make sure I could collect everything.
All right. We can set that in the afternoon, considering that we'll have, do you expect witnesses too, Mr. McKinney, or just arguments?
I would expect just Mr. Weston as a witness, so the defense can be ready and prepared at any time.
All right. I'll set it for the 22nd, though, Mr. Snell, considering that this doesn't appear to mandate a prison sentence. If you get that information sooner, please convey that to Mr. McKinney so we can advance it. I'm not saying I won't impose a prison sentence or incarcerative, but since it's not mandated, I don't want him to sit in jail any longer than necessary with that as a potential option. So if you get the information sooner, let Mr. McKinney know, and I'll advance it on the docket to the soonest available.
Yes, sir.
All right? So now, with all of that, has Mr. McKinney answered all your questions about the plea and how it affects you?
Yes, sir.
And are you satisfied with how he's represented you in this case? The court will find the plea to be freely and voluntarily entered into. We'll set it for sentencing on 1/22 at 2 o'clock with the understanding that it can be advanced if the information is obtained sooner. All right. Thank you very much.
And for clarification, adjudication, discretion of court, he's
Yes.
previously adjudicated guilty already.
He was already, Mr. McKinney, he was already adjudicated guilty, so that would not be within the discretion of the court. Okay.
Did you have-
Thank you, Madam Clerk.
did you have-
Was that at the time of sentencing?
Say again?
Was that at the time of sentencing on 5/14? Because my file indicates a withhold.
Let's see, I just pulled up the fingerprints, and it was on the minute sheet.
That could have been changed at the time of sentencing, but
5/14 adjudicated guilty. and-
Well, we need to check that then.
yes, sir.
Well, I'll leave that as is, Madam Clerk, and let's confirm that. That could have been an administrative issue. So, Mr. McKinney, you
Yes.
check your records. Mr. Snell, you check your records if the adjudication is correct or not.
Yes, sir, and I will double check that on my side
Okay.
as well.
All right, very good. Now, who else do you have in the back, Charles? Who else do we have in the back?
We have Johnson, Smith, and Grace.
Okay.
That's what Weston Giants.
Are you prepared to cover that for Mr. Cochran, or is that going to be a continuance?
The sentencing portion of that is going to be a continuance, and I am familiar enough with the case to stand in for Mr. Cochran.
Okay. So the sentencing will be continued, and what we have is a motion for judgment of acquittal, correct?
Yes, Judge.
And that's post-verdict, and it's in writing, so it wasn't made at the time of trial, but my review of the file is that it is timely.
Yes, Judge, it is.
Okay, all right. Let's have Mr. Gines.
Jason McKinney standing in for Chris Cochran for Mr. Gines. This is scheduled for sentencing on the docket. However, there was a mitigation report prepared for the defense. I believe that that needs to be shared and provided to the state, is my understanding of the case at this point. I believe that would need to be done prior to sentencing, so we would request a continuance as to the sentencing aspect of today's hearing.
And you do have the report at this time?
Yes, Your Honor.
Okay, so that just needs to be shared with the state.
Yes, Your Honor.
All right, let's proceed with the motion for judgment of acquittal.
And Judge, I do know that Mr. Cochran filed a motion for judgment of acquittal after the verdict, and I believe that we could address that on the motion at this point, if the court is so inclined.
Please proceed. And I've reviewed the motion, and I've reviewed the state's response.
Yes, Judge, and we would be comfortable with the court ruling on the documents and the filings at this point, as that was filed by Mr. Cochran.
Anything outside the response or the motion the state wishes to present?
No, Your Honor.
All right. I've reviewed that. I reviewed my notes of the trial as well. I reviewed, and to be clear, this is a preservation. There was an appropriate motion at the end of the state's evidence. There was a renewed motion at the end of the trial, and this followed in a written motion, which was timely and appropriate. After reviewing all of that, the standard, of course, is that the court must look at all evidence in the light most favorable to the non-moving party, and reasonable inferences therefrom, and light most favorable to the non-moving party. And the court must conclude that there may be no view of the evidence that the fact finder could make other than a judgment in favor of the moving party. I believe that is the standard. The extraordinary standard doesn't apply in this particular case that we would have for certain types of cases. I think you agree, Mr. McKinney, that the facts, the circumstances here don't suggest the court to apply the separate standard.
I agree, Judge.
All right. And so after review of that, after review of the motion, after review of my notes of the trial, and the evidence that the court heard, I cannot reach that finding that there would be no view of the evidence that the finder of fact could reach other than a judgment in favor of the movement in this particular case. And therefore, the motion for judgment of acquittal is denied.
Yes, Judge. That would leave us with finding a date for the sentencing, and I'll defer to the state, as I know that they need to receive and go through the mitigation report.
Is it the 25th, a miscellaneous date, of January?
No, I've got January 15 and January 22.
State is available for either. Madam Clerk, which docket looks less crowded?
They're both fine.
The 22nd, I think, is the day before jury trial review.
That's correct. 22, jury review is 23.
Thank you.
Because docket day is the 20th.
Given the holiday of the week of the 19th, what about the 15th?
That's fine.
15th at 2. let's take Jared Smith next. Good afternoon, once again, is Mr. Nopes.
Good afternoon, Judge. How are you?
Good.
Oh, there you are. Hey, Mr. Nopes.
Hey. So, Judge, Mr. Snell and I chatted about this case this morning. I know that the underlying case, the new law violation, is set for trial to be tried your next trial week. Let me look here. Yeah, so we got pre-trial conference January 12th. So I think both he and I are more or less contemplating that the court would just not sentence him today on the VOP and let us resolve the new law violation, and maybe we'll just have a result on everything at that point.
State?
Well, my understanding is that, I think that there's some talk going back and forth about a way to resolve everything together with short of a trial. And that's what I was thinking that we were gonna sit down and try to do. And then have some type of stipulated.
Well, that's what I heard Mr. Nopes kind of infer.
Okay.
That all y'all were gonna talk. We're still set for trial. It's gonna go to trial on 1/12, or there's gonna be a voluntary resolution.
Why
Like
can't we
Mr. Nopes is
resolve it
saying,
today?
don't sentence, because that leaves open the opportunity for a resolution. Am I reading between the lines wrong, Mr. Nopes?
That's absolutely what I hoped you heard.
That's what I heard. So you're still willing to talk about a voluntary resolution of everything?
I am, yes, sir.
Okay, all right, so we'll leave it set for 1/12 for the next cycle, and y'all continue to talk.
All right, thank you.
All right,
Thank you, Mr. Nopes.
You're welcome, Judge.
Yeah.
I also showed Dana Melson, Melson, 23, yeah, 1941.
yes,
I think she's still in Chattahoochee's. The bailiff said that it said on the docketing or the booking sheet that she was in another institution, so I think she's
correct.
still,
And what I did, Mr. Nopes, with that information is I simply reset it for another 6 months competency review. And as you weren't here, I was reminding everybody, I didn't do that when I first came back to this bench, but if you recall, when I was here before, on every one of those folks where they've been committed, I want to so look at your files. Anybody that doesn't have a review at 6 months, let me know and let Fran know, and we'll put them on for 6 months. That way, we'll be sure to reach out to the hospital and be sure we're doing what we need to do. Because it seems like we're not getting those reports timely, so I want to be sure that nobody gets left without an appropriate review. So I set her for 6/12. I mean, 6/11.
6/11.
And that's just for a review. And so if you don't see anything coming from FSH around that time, reach out to them and let's see where we are.
Okay, very good.
All right. Thank you, Mr. Nopes.
Thank you, Judge. Have a great day.
You too. Bye-bye.
Judge, this is Jesse Grace. Mr. Grace is before the court in 18 CF 2405. We've reached an agreement.
All right.
The agreement calls for Mr. Grace to admit to the violation of probation. He would be adjudicated. He was previously adjudicated in this case. It would be a 24-month Department of Corrections sentence with credit for time served from the date of the violation of probation arrest. That would be waiving prior DOC credit.
Okay.
To get to this agreement to revoke and terminate probation with the standard $100 VOP cost and the $150 cost of defense. May I approach?
Granted.
That is going to show as the score sheet reflects 105.6 points, but the state, I believe, has taken that into consideration with the waiver of the prior DOC credit.
And that would be a presumptive score of 58.2 months, is that correct? Yes, so it is a technical downward departure, but he did do 48 months DOC in the original underlying case. So actually, he's doing more than guidelines with his 24 months.
All right, raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, Your Honor.
Okay, and you put your hand down. Now, you heard what Mr. McKinney said, and you signed the written plea form.
Yes, Your Honor.
All right. Now, we were here today for the purposes of having a trial on your violation of probation, right?
Yes, Your Honor.
And now you've announced that you voluntarily resolved that, and that's what you want to do today.
Yes, Your Honor.
Okay, all right. You signed the written plea form,
Yes, Your Honor.
and by this written plea form, you're admitting the violation. Do you understand that?
Yes, Your Honor.
And that says to me that you agree that you violated your probation just as the affidavit and report says you did.
Yes, Your Honor.
And do you understand by making this plea, you're waiving your right to a trial, a hearing, where the state would have to prove your violations in this case?
Yes, Your Honor.
And by waiving those things, you've agreed to be adjudicated guilty and sentenced to 24 months in the Department of Corrections with credit for time served from the date of your VOP arrest.
Yes, Your Honor.
Now, the reason that's important is ordinarily everyone is entitled to all credit for the time that they've served, whether on this arrest or a prior arrest. But the agreement here calls for you to waive your prior time except from the date you've been arrested on this violation. Do you understand?
Yes, Your Honor.
Now, I don't know what that other time is, but, so your 24 months would begin from your arrest on these VOPs. Do you understand that?
Yes, sir.
Okay. And you'll have an additional $100 cost of prosecution, and $150 state-provided legal assistance added to your fees and costs. I'm not sure what your outstanding fees or costs are, but I'll give you 24 months to pay after your release from prison. Is that good?
Can I get a year?
He said
24 months. All right. All right. Mr. McKinney answered all your questions about the plea and how it affects you. And are you satisfied with how he's represented you?
Yes, sir.
I'll find the pleas to be freely and voluntarily entered into, and I'll accept the plea. Thank you. All right. Mr. Rolandi, please.